Good afternoon. It is with great pleasure that I welcome you to the Rule of Law Conference organized by ELSA Austria, ELSA International, and ELSA alumni. Friends, colleagues, Your Excellencies, please switch off your mobile phones now. Thank you. This session will be streamed live on the YouTube channel of ELSA alumni. If you wish to hashtag, it's ELSA Rule of Law. Without any further ado, I give you Federal Minister of Justice of Austria, former President of ELSA Vienna, a former ELSA member, a current ELSA alumni, Alma Zadic. Please, Alma, go ahead.
Excellencies, ladies and gentlemen, dear ELSA members and fellow ELSA alumni, I'm delighted for the opportunity to address you on the occasion of the 14th anniversary celebrations of ELSA. The personal experiences I've drawn from my time in ELSA Vienna and ELSA Austria have been an invaluable asset in my private, but especially in my professional life. Friends that I met there remained friends until today. I'm also particularly proud that the anniversary celebrations are taking place here in Vienna, where ELSA was founded back then in 1981. Although celebrating 40 years, ELSA is showing no signs of a so-called midlife crisis. To the contrary, today ELSA connects more than 60,000 students from 44 countries and is as vibrant as ever. This also proves that ELSA's vision of a just world in which there is respect for human dignity and cultural diversity has not lost any of its importance and relevance even after 40 years. And I'm confident it will remain topical also for the next 30 years to come. The rule of law, which is the topic of today's conference, is the foundation of our society, and it is the key factor to enable a just world as envisioned by ELSA. Upholding the rule of law has been such a prominent feature of the political debate of recent years, particularly at the EU level. In my view, it is key to promote the culture of the rule of law and to enable mutual learning between member states. And of course, the exchange of experience through intensive discussions. In July this year, the European Commission published its second rule of law report. And I'm very thankful that this rule of law report is being issued now for the second time. Overall, the report shows many positive developments in the member states, including how the challenges identified in the 2020 report were being addressed. However, concerns also remain and have intensified with respect to the developments in certain member states, in particular with regard to the independence of the judiciary and the situation of the media. These developments remind us how fragile the fundamental commitment to the achievement of the rule of law is. The European Union is a community of values, and it standardizes the rule of law in its treaties as a fundamental principle and establishes it as a prerequisite for admission. And although this principle is one of our fundamental principles and is also well known, it's not easy to find a comprehensive definition of what this entails. A valuable orientation is the catalogue of substantive rule of law criteria drawn up by the Venice Commission of the Council of Europe. It identifies, amongst others, human rights, legality, legal certainty, the prohibition of arbitrariness, the principle of equality and non-discrimination, and access to justice as overriding criteria. In my capacity as Minister of Justice, I wish to particularly highlight one indispensable element of the rule of law, which is the independence of the judiciary. It has been highly disturbing with which vehemence the Austrian judiciary has lately been repeatedly under attack. The principle of separation of powers ensures that the judiciary can work independently, free from influence from the executive branch, free from influence from the government. The independence of the judiciary is a central achievement of a democratic and just society and must therefore be vigorously defended. Unsubstantiated and unobjective attacks against the judiciary, against judges and against prosecutors are attacks on the rule of law and also endanger the trust of the citizens in the work of the judiciary and therefore also in our democracy. Furthermore, an independent judiciary also needs the necessary resources so that it can also provide quality, predictability, and an appropriate duration of proceedings. And one further challenge, not only for the judiciary, but also for the society as a whole, was of course the omnipresent COVID-19 pandemic. The global health crisis demonstrated the importance of maintaining the separation of powers and the rule of law. The mentioned rule of law report also noted the strong resilience of the rule of law during the pandemic. Such a health crisis can recur at any time, which is why judicial systems need to be prepared, especially when it comes to finding effective solutions to ensure access to justice for everyone, while also at the same time respecting individual rights. The use of new technologies and the digitalization of justice played also a key role in this regard, as they enable the judiciary to function even during a lockdown. However, IT solutions such as online services, remote hearings, video conferences must always ensure the respect of the fundamental rights and the principle of a fair trial. The impact of the use of these technologies on the administration of justice should therefore be regularly evaluated. Finally, yet importantly, ensuring cybersecurity and the protection of personal data must be a priority when new technologies are used. In conclusion, I hope that discussions and events promoting the rule of law, such as today's Rule of Law Conference, will lead to more awareness and recognition of the fundamental importance of this principle. In any event, we should continue to fight tirelessly to improve our legal system based on the rule of law and make them more crisis-proof in the future. Thank you.
Ladies and gentlemen, dignitaries, the Chancellor of Justice of Finland, Tuomas Pöysti, former treasurer of ELSA International in his student times. I give you Chancellor of Finland, Tuomas Pöysti.
Dear friends of rule of law, when I was a law student and an active ELSA member quite a long time ago in the early 1990s, which was an era of optimism in Europe and optimism among all the law students, but also it was a rather dark moment of European history when we, the law students, we were touched by the war and war crimes in the former Yugoslavia. But in the middle of this optimism and historic experiences, ELSA adopted the philosophy statement, a just world in which there is respect for human dignity and cultural diversity. After a bit heated debate in the council meeting, to which I had a chance to participate. And I was among this little minority who didn't really understand at the time of the significance of this philosophy statement. An idea of which stated, an idea of learning in a spirit of critical dialogue was added to this philosophy statement of ELSA. At that time, I couldn't imagine how much the statement would in fact define in a nutshell, my own role as a lawyer and the role of all the lawyers in society. This has in fact been one of the guiding principles in my current duties as a member of the government of Finland, with double role to ensure the constitutionality of the actions of the government and all those vested with public powers, but also to have a look on the professional code of conduct of the attorneys and other lawyers representing clients in my country, and finally acting as a general ombudsman handling people's complaints. Lawyers and law students are carriers of the ideals of justice and the realization of the rule of law in various everyday circumstances. These kind of tiny circumstances as well, which may not be really fancy, but they are really important, because the rule of law is not something which is only in the books. It's something which every citizen in the world should live and experience in their daily lives. Today, rule of law is on the headlines, rightly, because it's challenged. But also, there is unfortunate virtue signaling, talk without content. Our societies need this critical dialogue, and we, as the present lawyers, my generation, and the future legal profession, shall question, do we, as individuals or professionals, when we speak or when we be silent, when we act or we refrain from acting and simply watch, do we safeguard human dignity and just society based on rule of law? The rule of law is an important foundation of a good society, and hence it needs to be taken seriously, and taking seriously means acting. Idealism and willingness to act is also needed. A second lesson which I learned as a young academic after graduation, I was invited to assist a group of enthusiastic academics who were at the time a little bit loved by the establishment. There was a problem of fraud and corruption affecting the European Union and its interest. And this group of academics, a mixture of young and very experienced, did propose a corpus juris, a common European principles of penal law, and the creation of a European Public Prosecutor's Office, EPPO. This was received by initial skepticism by all the realists. There were many turns, but ultimately the European Union founding treaties were modified. This year, 2021, the European Public Prosecutor Office, EPPO, officially started its operations. The lesson: ideals can change the world, or simply make it a little bit a better place. Rule of law has various definitions, but it is a common European principle which is covering the whole continent within the framework of the Council of Europe. Dimensions of it and definitions of it may vary, but we do have a common understanding of the fundamental elements of the rule of law, as Minister Zadic was also mentioning in her inaugural address. There is formal and substantive legality, which includes respect for human rights and fundamental rights, legal certainty, with transparent and open legislative process and accessible legislation, prevention of the abuse of powers, equality without discrimination, and fair trial by independent courts and with the help of independent and highly professional attorneys. The rule of law shall develop with societal challenges. Today, there are three grave challenges to the rule of law we should be aware of. The first one, the climate change, the loss of biodiversity, and the risks of pandemics, which is closely associated to that. And secondly, diminishing trust on the institutions of democracy and the institutions of rule of law, including the attacks against these institutions, and including corruption. And thirdly, security risks, including the risk of cybersecurity in our increasingly digital world. Climate change and loss of biodiversity, which go hand by hand, are the greatest planetary challenge to human way of living, democracy and the rule of law itself. Right to a healthy environment and protection of biodiversity and right to health shall have and deserve to have much more central position in the legal system of the future. The current pandemic tells also about that. The rule of law principles, including the stability and form and accessibility, shall also be guiding the way in which we protect ourselves in the pandemics and how we do prepare for the mitigation of the climate change. There are many questions of psychology and communication to citizens connected with the governance of pandemics, since the question is to have trust to the protection measures and convince people to change behavior. Rule of law requires stability and certain form exactly in order to create trust. Governments had a tendency during the pandemics to announce measures in the media without necessarily recoursing to the proper legal procedure. In my country, I, as the guardian of the constitutionality within the government, had to remind sometimes that a certain legality relevant to measures have also to be in the right form and procedure, not only substantially to the right direction. Legal measures shall be distinctive from mere recommendations. We also have to better include human-to-human solidarity, taking care of the interests of the other, health of the other, and horizontal protection of human rights between the relationship of two private individuals or two private companies in our constitutional thinking and legislation. Corruption erodes trust to democratic institutions. Work for transparency and prevention and detection of corruption is thus topical in the defense of the rule of law in today's societies. Corrupt practices do not only weaken public functions, but also they do weaken the integrity of the media and social media as an important platform of information, which needs to be guaranteed as a service to the citizens. Medias are arenas of our right to participate to public life. The Council of Europe Greco materials and some other international materials provide a common and living European set of standards, but these we need to develop further and apply them in the spirit of critical dialogue. We live in a very digital environment. My intelligent ring or my watch can know me better than myself. From the way I tapped my tablet, in fact, you could infer data about my characteristics. Privacy, in fact, in the future will entail right to fair extraction and inferral of information about me, fair use of automation and artificial intelligence which is reasonably explainable and under human control. And finally, cybersecurity by design, a realization of reasonable level of cybersecurity in all these digital applications. These technically sounding issues are an important part of the living rule of law and respect for human dignity. We, as the current and future lawyers, we are value ambassadors and value designers, ensuring that these features do appear in the digital environment and its architecture. Finally, in short, rule of law is much more beyond the virtue signaling or empty speech. It is a call for us, a call for all of us to act alone and together, finding workable solutions within the frame of the rule of law for a just world. This is our common application as lawyers and law students in the times of our world. Thank you.
Andy, Alma Zadic is available for questions for about 15 minutes if you would like to use that opportunity. She's following this call, but 15 minutes.
Okay, thanks very much. My name's Andy Ungerem. Everyone, hello. I'm from London, and I was the first president of ELSA alumni in the last century, and I'm the curator of this conference. Our next speaker is Dr. Jörg Krakow from the law firm DLA Piper, and he also is a representative of Transparency International Austria, which brings us back to the topic of corruption, which is a threat. I'm sorry, I completely misunderstood you. I thought she was going to join.
Of course, that's no problem.
Sorry, George. Okay, do we have any questions from the audience for Alma?
Dear Mr. Minister Zadic, dear Alma, you have been shaped by ELSA, and many of us have been. I want to ask a personal question. How has ELSA shaped you, please?
Well, thank you very much for this question, and I apologize that I need to leave this podium discussions a bit early. Well, first of all, ELSA shaped me in the sense that I met a lot of friends that I still have today. Friends that are not only in Austria, but that are spread all over Europe. And second, I think the one thing that moved me and the reason why I joined ELSA was ELSA's vision. That there's respect for human rights and dignity and cultural diversity. And I think that's something that that is with me since the very days I started. That's the reason why I actually wanted to study law. And that's one of this vision also attracted me to join ELSA. And because of that, and I carry that vision with me even nowadays in this office as a Minister of Justice. Having said that, I think that ELSA left a great impact on me, and some friends that I met during ELSA time also worked with me in the cabinet.
Any other contributions from the floor? Yes.
Hello, Alma. My name is Lisa Mead. I was on the international board of ELSA in, gosh, a long time ago, 1991. My question relates to your statement that the Austrian justice or the independence of the judiciary has been undermined in Austria, and I wondered if you could elucidate on how that has been happening specifically here.
Thank you so much. I wouldn't say that it's undermined. I would just say that it's under attack because there have been recent proceedings by the Austrian prosecutors, also measurements that the prosecutors have taken that went also through the judiciary system and that were somehow attacked by those indicted by the prosecutors or those where proceedings are still ongoing. So we witness on a regular basis attack on the prosecution, attacks on the judiciary, and this is one of the reasons why I think it's so important, and that's why I'm thankful to the civil society and the support, the massive support of the prosecutors, the massive support of the judiciary by the civil society, because it's an important pillar in protecting the independent judiciary.
I think we might have time for one more question. Yes, please.
Thank you. My name is Hubert Gams. I worked for ELSA Innsbruck, Austria, and then also for ELSA International in Brussels. And I wanted to ask you, what would you expect, what would you wish for from organizations like ELSA Alumni? What can we do to support, endeavors to protect the independence of the judiciary, to protect, the rule of law, besides having this conference here?
I think having this conference is a first and an important, well, not the first step, but it's an important step. Don't stop to talk about it, because I think it's important. It also does not only stop at the conference, but what you do when you discuss about these issues, when you discuss about the rule of law, of the importance of the rule of law, you also move other people and other organizations to do the same. And I think what I realized also in my function as the Minister of Justice, I'm very, very thankful for the civil society that is continuing the discussion about strengthening the rule of law, about the independence of the judiciary and also the independence of criminal prosecutors, because this is something that helps strengthen the rule of law, and it helps also strengthen the democracy, and it helps also make my job, because I see my duty to provide the necessary requirements that the judiciary can work independently, that the prosecutors can do their job independently, and having a civil society that backs this ambition it's incredibly valuable. And that's if I can ask for something, is please continue those discussions. Make sure you connect among each other and connect in the sense that with these aims, with these goals in mind. So I think that's important and helpful.
Thank you very much. Can we thank Alma once again for joining the conference?
Thank you very much. I really apologize that I won't be able to join the end of the discussions, and I hope to see you soon at one or the other occasion. Thank you.
Thank you very much. Jörg, you've been very patient, but the microphone is yours now.
No, I have not been patient. I have been curious, because, of course, I also have been interested in the answers of Alma, which speak right from my heart also. So, dear Minister Zadic, dear Chancellor Pjösti, the technique already goes to the floor, but we will manage to keep it on top. Dear colleagues and dear ladies and gentlemen, all friends of ELSA, I do not need to reiterate that the rule of law is an important pillar of our society and a necessity for democratic societies in general. I would rather like to turn to another aspect, one that receives little attention in many discussions, but is at least as important. On many occasions, rule of law is demanded of others. Politicians are criticized for not paying enough attention to the rule of law, and that is all justified and okay in many cases. But the other aspect is the personal dimension. Rule of law only works if the individual parts of society, which are the people, in their overwhelming majority, commit themselves to live up to the rule of law. If they also let the law rule in their own environment, if they themselves do not look for possibilities to circumvent the law and for loopholes with a twinkle in their eyes, but if they uphold the law. Numerous fundamental rights, for example, they already mentioned, right of privacy, only will function if they are lived and respected by everyone involved. It is of no use if they are merely written in the law alone. Rule of law also means renunciation. Renunciation of something that one would like to have and could perhaps achieve, but is not supposed to, because there is a law that says otherwise. In the course of this conference, there will be a lot of discussion about business and rule of law. This is a very elementary aspect in our days. In business, too, the application of rule of law in competition, for example, can mean that I give up a business opportunity in order to comply with the rule of law. The same, of course, is true in the political sphere. One sometimes gets the impression that the argument, the end justifies the means, regrettably prevails. If a subjectively good end is being pursued, then there seems to be no need to look so closely at compliance with the law. This is what some people say, and this is how some people act. For example, when confidential documents from investigative committees are deliberately made public in intentional violation of the law, with the argument that the good purpose of public information requires this act. One cannot claim the rule of law, but want to establish for oneself the very law to which one is bound. This is exactly the opposite of a rule of law. The term rule of law also is often abused in these days. If a decision of a court or a prosecutor's office fits into one's own concept, then it's trumpeted that this is proof that the rule of law is applied and prevails. And if a decision does not fit, then it is claimed that this is a proof of dark influences and manipulation. Such thinking is how the rule of law and the constitutional institutions of a country are damaged. Rule of law also means accepting legally binding decisions of the judicial authorities if one believes they are incorrect. And criticism is always permissible, but critics should be factual and not aggressively emotional, especially when it comes to essential elements of our constitutional state. We are experiencing a time in which, unfortunately, there is too little factual discussion, but much more arguments ad personam. When someone makes an argument that goes against the grain, it is not argued against what people say, but rather the people who make this argument come under personal attack and are defamed. That is very detrimental. That leads to a disintegration of the possibility of dialogue in the long run, which is also an essential part of acceptance of a legal system and thus of rule of law. Because like I said before, if it is not the case that an overwhelming majority of people believe in the law in a democratic society, then there will be no rule of law, no matter how many pages you print full of laws and letters. So I urge each and every one of you to stand up for the rule of law, not as an abstract philosophical principle, but as a necessary condition for personal freedom. Lack in rule of law means lack of freedom. ELSA, as an organization that was founded 40 years ago, has already experienced quite a lot of contemporary history. From this point of view, ELSA is predestined to work on the long-term project of rule of law. We must always work on rule of law, and this work will never be completed. Thank you very much.
I'd like to pick up on a point you made, Jörg, about standing up for the rule of law, and just to invite everybody to pay attention to the rule of law project that we're going to present later on this afternoon, because that's a very concrete and immediate way in which we can actively support the rule of law and not just declare our support for the rule of law. I've been trying to think what is the opposite of virtue signaling, Thomas, because we certainly have a lot of the opposite in the UK. I think it might be disrespect signaling, but it seems to be that politicians seek the votes of people who have become strongly anti-establishment. And there are votes and elections to be won in disrespecting the judiciary. And we had a headline that called the judges in a particular case the enemies of the people. And so we're at a very dangerous time now, and we do all need to stand up for the rule of law. We've got time for a few questions or comments from the audience, and then we will close this opening session. Yes, please.
Hi, Rob from ELSA International 1995. First of all, thank you to the organizers and to the speakers. What we've heard this morning has been truly inspiring, so thank you. As a friend of ours used to say, 2 points. Thomas, well done for choosing such a challenging and unselfish role. I think the demands of being a Chancellor of Justice must be a very difficult job. So on behalf of the rest of us, thank you for setting such an example. My question to both of you is, we see in a country like New Zealand that, for example, if a government wants to budget something new, there's an independent committee where the government has to actually justify how it's going to finance that. If it doesn't do it, it doesn't get approval. That's a dream for maybe the rest of us. The question I wanted to ask you is, given the way observance of rule of law is being linked to European Union financing, how do you see that difficult challenge evolving over the next years? Thank you.
Shall we take a couple of questions and answers?
Yes.
Yes, please.
Okay, thank you. Andy, great to see you in a tie. Finnair lost mine, but it should be coming later. Gary Parker, ELSA, England and Wales, UK, and SecGen of ELSA International 95. Thomas was our treasurer. And I'm reminded by his speech, having now been Chancellor of Justice, there's a wonderful picture in the National Museum of Finland called L'Attack, The Attack by Edvard Isto. And as the Finnish maiden, the Suomennetti, being attacked by an eagle, and she's holding the law book, the law book. And, you know, having quite a substantial border as we do now living in Finland with the Great Russian Bear next door, my question is really linking also to George and Transparency International. How do we preserve the individual rights? How do we defend not only our own countries under the rule of law from the attack, wherever it may come, and what can organizations like ELSA and our alumni do or continue to do to develop solutions to the undermining of the rights and the freedoms of speech and movement that countries neighboring to us are suffering? I started in ELSA in '89, and that was the year the Berlin Wall came down. There was a lot of us that were active in that period, and then the Balkans, and also with a solution for Cyprus and other places. Now we have something in Ukraine and issues in Russia. What can we do?
One more question, and then we'll give a final word to our two guest speakers.
Hi, my name is Marcelina. I am from Poland. I used to be director for public relation in ELSA International like 8 years ago. Now I am not a jurist, but a journalist. And my question is, because I am from Poland, how to explain my citizens why rule of law is so important? And also, Mr. Krakow, how do you understand freedom? Is there any elevator speech for rule of law?
All right, thank you. George, would you like to answer first?
Of course. Does the microphone work? Yeah. Well, to the first question, I would like to say that I believe it is practically the first time in history that states are held really accountable within a rule of law system and not just by interstate agreement. And that makes a huge difference because that goes to the core of the self-understanding of the concept of a state as an entity that has no superiors, only equals. Suddenly, there is some senate of a court far away in Luxembourg who decides if a government, the representatives of a state, have acted right or wrong, and they will find a verdict, which can go both ways. But it's beyond their reach, and that is a quite new concept for states. It is a phenomenon of integration in Europe, and you see and you can feel at the emotionality of the discussion that goes with it and the compromises that have to be found, that it is a very difficult path, but it is a path that states in Europe have begun to climb. And I believe it is a very, very important piece of also a rule of law-based system all over Europe, which will help rule of law in all these countries in particular, but also on the level of the European Union and in Europe. Second question, what can be done? In essence, I would say first, education. It is always the most important thing, but not only education, but interesting people in the material. I am a little bit afraid of a lack of interest, because we live still, despite the pandemic, in quite comfortable times most over Europe. And it's so comfortable. So we have another Netflix series in the evening, and this is much more convenient than going to some conference and have discussions where you have really to think hard and maybe face arguments against what you think personally. So activity. Without activity, we are just like a number, a figure of people without a will. Activity is the second issue. And the third, what can ELSA do, for example? I think organize events, also small events, and include as far as possible, as many as possible, people from countries with a lack of the freedom that we enjoy. Because I believe this way, the thinking of rule of law and the thoughts of freedom can be spread quite effectively, not within days, not within weeks, but it has worked already in history. And communication and openness is, I believe, the most efficient way to change societies over time. Just one sentence more to this issue. To my experience or to my belief, we often find that something is not okay, we must change it. And then we desperately seek how to change it, and we expect that everything can be changed from one day to another. This doesn't work. Certain things need time. Political systems to change need time. Yes, then maybe it happens very quickly, but until then it needs time. So we should not lose patience. And the third question, if there is a definition of freedom, well, basically yes. Freedom is when I can do what I want as long as I don't inflict harm to another person. I think that's a very basic description of freedom, and there is no freedom when other people tell me what to do, even if it is not justified for the greater good.
Thank you.
Thomas.
It functions. Thanks for Marcelina, for our Polish friend, for this very, very important question. How do we explain this rule of law? And in short, I agree with what Georg already said. But I think we could add that we could try to explain that the real freedom, real sense of security, and also a feeling of greatness and proudness as a Polish citizen, Finnish citizens, UK citizen, whoever citizen, is also based on the fact that I can make a contract, and that's respected. if I'm given a promise by the public power, that's respected. If I carry on business, so I can negotiate and freely do my business deals, and they are not surprisingly, arbitrarily put down by unfair competitors or by unfair public powers, and making that very, very clear. I have a feeling that in some countries of Europe there are kind of shadows of history which mean that the nation has a kind of belief that it has been trumped and trumped throughout the history, and so by claiming this kind of false political supremacy, what is supposed to be the people's will. And it's not only the issue of Poland. There are people also in my country who have this kind of that lawyering is a little bit like enemy of the people against this kind of populist argument. So we have to simply patiently explain that you are wrong. It's not like that, and therefore what we also need to do together and individually, and there are all kind of associations, ELSA, alumni type of organizations, business chambers of commerce, business associations can also communicate what is the value of having this set of rules, and also for lay people. And he asked about what is the opposite to the virtue signal, and I think it's this kind of a politicization of the justice system and legal argument, and stigmatizing as people's enemies or things of the kind. And that's a serious problem in nowadays, and that comes to this kind of seminar of the 1995 international board members, and this Gary's excellent question. And so I would also say that we could, as this kind of non-political independence association, we can support these colleagues of ours who either being business representatives or independent attorneys or human rights defenders or in some public functions, in judges, for example, who became under the attack. It also helps to have this kind of support from the colleagues from other countries to simply to continue to keep the spirit on, because it's when you are attacked, it's very heavy experience on a human level. So this is also one important thing we have, and recently we among the constitutional guardians, we have been talking that we really need to support these colleagues of ours who are in the difficulties. And finally, on this Robert's question about this rule of law and financing, and this is my personal opinion, because the European Union came to an agreement. Firstly, the regulations which are at force currently, they are in the rule of law field, they fall much shorter than this kind of rigorous economic assessment system in the New Zealand. But that's something what we have agreed together. They are not the most perfect rule, but they are common rules all of us agreed together. So sticking really to letter and spirit of those rules is already a good beginning, which means that if there are this kind of suspicions that these weaknesses in the rule of law in a certain member state is having an impact on the financial or other interests on the European Union, both the national authorities supported by the civil society and this new European institution should really rigorously investigate them, and then we apply this regulation. It's at least a good beginning. And also the rule of law mechanism and this comparison by the Commission, it's rather good to which also all the civil society actors can participate. The Commission is broadly seeking for consultation, so these are in fact also the discussions where we could have a wide front to do that. So in a nutshell, apply this existing rule, and of course in the future I hope that we will have a more rigorous rule also on that.
Thank you very much. One final sort of comment on what can we do to uphold the rule of law. It was in Vienna in 1993 at the end of the Cold War that the UN held its second International Human Rights conference, and one of the conclusions in the declaration was a very strong link between democracy, human rights and the rule of law and poverty. And I'm saying that because one of the ways in which we can uphold the rule of law is through our actions. Lawyers are a very easy target, so when the newspapers call the judges the enemy of the people, they're playing to the gallery. That's what people think about lawyers anyway. So I think we have to get out into our communities, and the Role project is going to be one way of that. But the other one is to do what in the UK we call pro bono work, helping people who can't afford lawyers. Now, traditionally, that's either criminal lawyers often very young, acting for clients in the criminal courts, or it will be civil law, it will be people with housing problems and social welfare problems. But actually, in many, many communities, there is a huge need for support for small to medium enterprises and people starting businesses, a way in which they lift themselves out of poverty. And we as lawyers can support that. Not everyone can afford the lawyer. And it seems to me that if you're helping people in your community, whatever your area of expertise, I think you can find some way to do that, then we model all of the good aspects about the law. And I think we can't just sit back and worry about the rule of law. I think we've got to, each and every one of us, be more active in upholding it. So please join me in thanking our three speakers, one of whom has left us. The next session is going to be on business and the rule of law, and it's going to be convened by Kolfina Tomasdotter, an ELSA alumni. And while the next panel come up, could I invite the president of ELSA Austria, Alexander Capro, to come up and say hello to everyone. We owe him a big vote of thanks because ELSA Austria have helped us tremendously in organising this. And so I would like him to say a few words.
Thank you, Andy. Thank you very much. On behalf of the whole Austrian network, I would really love to welcome you to the Rule of Law Conference. It is indeed happiness for us all in the Austrian network to see you all today here after 2 years of a pandemic, after no physical events, after sitting hours in front of a computer, to be able to sit here with all of you. I would like to thank all the speakers until now for their insightful contributions and all the speakers that will follow up. And I think I would like to thank especially the association that brought us together today, ELSA. ELSA taught me during the last 4 years I've been active, a lot of skills, soft and hard skills, helped me meet a lot of interesting people and take part in a lot of insightful events. And I couldn't imagine my life today without ELSA. So without further ado, I would like a round of applause for the association that helped us grow and made us be here today. Thank you very much.
Dear guests, it is an honor to be here with you today, both in person and online, to discuss the significant topic of business and the rule of law. My name is Kolfina and I will be chairing this session. Today we have the privilege to listen to 4 great speakers with various experience to give us an insight to this important topic. They are Barbara Zelos, Deputy Head of Staff of the Austrian Competition Authority and Team Leader of Inspections; Marlene Halekias, Head of Advisory at Grant Thornton in Austria; Moritz Amende, Partner at Schima Meyer Sterlinger Attorneys at Law; and Wojciech Vyarovsky, European Data Protection Supervisor and a Professor in the Department of Legal Informatics at the University of Kedamsk. As in the previous session, we will be taking questions only at the end of the last presentation. So to highlight a few points before we hear from our speakers, I want to mention that in the world we live in today, business has a large role in supporting the rule of law. Over the past 20 years, there has been a significant focus on international frameworks and principles to help guide responsible business. There are multiple tools available for that, such as the UN Sustainable Development Goals, the UN Global Compact, the UN Guiding Principles on Business and Human Rights, the UN Business for Rule of Law Framework, as well as the International Bar Association's Practical Guide on Human Rights for Business Lawyers. As an example of this, we have Article 13 of the Guiding Principles on Business and Human Rights that refers to the responsibility to respect human rights and requires that business enterprises avoid causing or contributing to adverse human rights impacts through their activities. The IBA's Practical Guide on Business and Human Rights for Business Lawyers then provides an accessible summary by explaining the background and core content of the UNGPs, its implications and challenges. Other principles can, for example, be found in the UN Global Compact, where it is stated that business should undertake initiatives to promote greater environmental responsibility and work against corruption in all its forms, including extortion and bribery. Strong rule of law is essential to ensure economic growth, social and sustainable development, human rights and access to justice, and each of these tools that I have mentioned play a part in that. They play a role in engaging businesses in building and strengthening their legal framework by being a standard on business and human rights that is relevant in all fields. As Ban Ki-moon, former United Nations Secretary General, said, "Where the rule of law is strong, people and businesses can feel confident about investing in their future." I believe that his words are more important today than ever. Today, I wish you a fruitful session, and without further ado, I welcome the first speaker, Barbara Selos, Deputy Head of Staff of the Austrian Competition Authority and Team Leader of Inspections.
Thank you very much for having me here today. It's a great honor to represent the Austrian Competition Authority and share our view on the rule of law in business. As you all know, the rule of law is a set of criteria, like a durable systems of law, institutions, norms, and the community commitment that delivers a well-functioning system. According to the United Nations, the rule of law and development are strongly interlinked. Rule of law is fundamental to international peace, security, and political stability. So now let's come to competition law and what that can bring for rule of law. First of all, competition agencies play a very crucial role for the functioning of the market economy and a fair distribution of wealth. Without a healthy market competition, there is no well-functioning economy. Basic economy theory demonstrates that when companies have to compete for consumers, it leads to lower prices, higher quality of goods and services, greater variety, and more innovation. Therefore, an effective cartel and merger control enforcement is important to achieve a stable market economy and is also part of fulfilling the rule of law. So what is now the role of the Austrian competition system and the Austrian Competition Authority? The specific Austrian design of competition enforcement is particularly diligent in complying the rule of law principle. It is different to the majority of enforcement models in the European Union, in the EU, including the European Commission. We in Austria have a separate enforcement system which consists of an investigative body, the Austrian Competition Authority on the one hand side, and a decision-making body, the cartel courts, on the other hand side. The binding decisions in antitrust law are taken exclusively by the specialized cartel courts upon application from the agency. The fact-finding instance of the cartel court decides in the form of a 4-member senate, which consists of 2 professional judges and 2 specialized lay judges. The Austrian system therefore allows a very high standard in terms of a fair and transparent procedure according to fundamental laws like the right to be heard and the right of self-defense, and overall obeying the rule of law. And let me give another very specific example. In cases of bid rigging, the criminal and the cartel law bodies investigate the same case. A leniency program addendum, right now currently in the status of a draft addendum, which foresees a prolongation of this right for 7 years, is linking both the legal system and the competition system to allow employees of cartel leniency applicants to receive also a leniency status under criminal laws. So if there is a leniency applicant before the Austrian Competition Authority, the employees, and if they fulfill the circumstances of full cooperation, can also be granted a leniency application status under criminal law. This is also a part of guaranteeing the rule of law beyond the core cartel law. Additionally, let's have a view on our investigation tools. The Austrian Competition Authority can conduct on-site investigations, also called dawn raids. Arguably, the most intrusive investigation tools the competition agency has, and it is bound to a strict court decision requirement. So in conducting dawn raids, the competition agency is functionally acting on behalf of the judiciary. So it's operating like an arm of the judiciary. If the agency exceeds the court order, these actions can be brought to the administrative court and be subject for further review. Apart from the legal framework and the legal obligations, it is a high priority for the competition agency to adhere to fair, transparent, and open government principles. For example, the agency uses soft law, self-binding soft law, to give undertakings guidance, which is published on our homepage. The agency published 23 sort of these guidances, and one of these is a guidance on dawn raids. And as far as I know, we are the only agency who did that so far. This guidance gives explanations for the conducted company, but also for the employees on the procedure of the dawn raid and also the legal protection possibilities. Apart from that, undertakings use the possibility to address the competition agency with competition questions like procedural questions and pre-notification issues before a merger is lodged officially. In general, for the market economy, it is crucial to have a reliable competition agency which acts swift and agile. We are aware of our important role for economic growth and the common good. We do the utmost possible to stretching our limited resources to achieve a very high standard of quality. Having one of the fiercest competition enforcement procedures in force, one might think it is more difficult for being successful as an agency. Just let me share one number with you. Only in 2021, in this year, we will, till the end of the year, we will apply more than 100 million euros of fines before the cartel courts. And I think alone this number proves that we are quite successful as an enforcer. In my opinion, this proves that obeying the rule of law and being a strong enforcer is not a contradiction. In the contrary, I would say that these obeying the rule of law are key success factors for our agency, besides, of course, adequate, well-trained staff and an independent enforcement body. In my opinion, the rule of law, in the previously described sense of cartel enforcement in Austria, is also contributing, on the one hand side, to increase the deterrence factor for potential cartelists, and on the other hand side, very important, to increase the intrinsic motivation of our staff to enforce for the overall good. To sum it up, the rule of law is not something we experience as troublesome or burdensome, but it is the foundation of our work and the framework of our daily business. Thank you.
Sorry. Thank you very much, Barbara. Next, I would like to invite Marlene Halekias, Head of Advisory at Grant Thornton, Austria. Welcome.
Thank you very much. My name is Marlene Halekias. I'm Head of Advisory and Partner at Grant Thornton in Austria. And in my core business, I'm auditor and advisor. So you can imagine I rely heavily on the rule of law and its implementation. So I rely on business framework with common rules, on business principles, on good governance and reliable lawmaking in the jurisdiction. And I think you already have it all in your minds that I rely in my profession, or more to say, I really count on you all here. My profession is proving financial statements. It's giving advice for good governance and searching for inconsistencies or reveal misleading information. And that would not exist without the rule of law. And it would also not exist without a standard of governments of the European Union and of a common understanding of our foundation, how we should live and how we should do business. And so, in my understanding, we have tested principles, time-tested principles in our society and in doing business, and we all rely on them. And now, in a digitalized world, we find that we have to take a closer look at them and what is implemented and what are these time-tested principles. And we may be confused of what we find, because we see that there are algorithms and they interact with each other. And we see that even without notice of any authority, business is done. We see that big tech companies are gathering information and intelligence, and they monitorize our interactions and our private life. And we also see that there are trillion-dollar networks on a blockchain basis, which seem to be beyond the rule of law, or beyond at least a state rule of law. So I work a lot with new tech companies and decentralized payment systems, and that operate decentralized, and they trust only the rule of mass, and that's what it seems. But that is basically nothing new, because what those new tech companies do is that they only improve the possibilities that we already had with the internet for 3 decades now. We had those possibilities of communication and business that goes beyond borders or beyond boundaries. So here is my hypothesis, or what I understand, is that the rule of law is not replaceable, even not in a digital world, because we all need a foundation. And yes, there are blockchain technologies that facilitate automation and interact, and even facilitate private regulatory frameworks. But we also know that those blockchain-based companies, they can try to seal lack of rule of law in some states where, for example, they give, or when it comes to property law or to payment solutions. But in generally, I think that peer-to-peer business would not be successful without implementing state regulations, without respecting jurisdiction, and without accepted, regulated institutions and authority, like Barbara mentioned. And this is a question of trustworthiness, and it's a lot of questions behind it, like preventing money laundering. And I give an example, like nowadays we have those crypto coin offerings, which are offerings of crypto assets to the market. And they lack a regulation compared to the offering of normal, traditional stock shares. But now you find that regulation is coming up, and there's certain coin offerings that are close to securities, like security token, and they result in regulation. So prospectus have to be made, information has to be given to the token holders in future, and so on. And that shows that even in a new technology area, and even in a decentralized area of business, there is a need for trust in the investors and for trust in the market. And the trust is given by rule of law. So there is a desire in new tech companies to have rule of law, even if it's not always visible. And for me, also another very, very good question for this are non-fungible tokens, the NFTs. So NFTs, they are unique, and it's non-interchangeable unit of data. It's not replaceable. It's maybe a little bit like the St. Stephen Cathedral in the middle of Vienna. It's unique, it's not replaceable, you have it only once. And there is a natural human desire to own something that is unique and to trading something that is unique, to do business on it. And this desire is something for me, very applicable to the rule of law, that we need it all. So you have NFTs, they are a result of this desire to create something unique, and even though you have a system of endless possibilities. And we all know that having something unique is often not enough for us as people, as Homo economicus. So we tend to make business. And we also have to do business with those modern new technologies. And for the business, we need a reliable field. And there comes the rule of law. And as a result, today, even digital natives, they trade their NFTs at Christie's, at a fierce playground where they can rely on. So my opinion or expertise tells me that wherever there is rule of law, business can be made, and it's a foundation of good business. So rule of law is the key, and I would not be able to do my business without these principles, to give a good and lawful advice, a sustainable advice, without this foundation or basis. I think also my colleagues from the forensic and cybersecurity team are in the room, and so we have seen firms and managers who are ignoring principles of good governance and of rule of law. And we have seen this in all kinds of businesses. So this is nothing to do with new tech companies, but you can find it in all kinds of businesses. It's just unlawful behavior, not adhering to rule of law. So I think this is a behavior we all want to prevent, you as jurisdiction, as lawmakers, as maybe future political deciders, and us as business auditors and advisors. So together, I think we have a common understanding of the importance of implementing and of respecting principles of rule of law, and on state level and also globally. So I thank you for inviting me today. Thank you.
Thank you very much, Marlene. I think when you said that trust is given by rule of law, that sums the importance up very well. Next, I would like to welcome Moritz Ente, partner at Schima Meyer Sterlinger, attorneys at law.
Thanks a lot. It's a pleasure to be here with all of you. It has been too long. Some of you may know me because I've been around in the alumni world of ELSA for quite a while as former president of the ELSA Alumni Society. I'm also a founding member of ELSA Luxembourg, something I'm particularly proud of. And today, yes, I'm a partner for competition law at Schima Meyer Sterlinger, attorneys at law in Vienna. Now, I was asked to say something about the relevance of the before-mentioned United Nations Global Compact for a business lawyer like me. Now, I've been told that honesty is one of my virtues, so I'm a bit sorry to be the party pooper in the room, in that I have to say, well, for me, the relevance is zero. Actually, I never even heard about it before I was asked to comment on it. So I thought, okay, maybe that's just me, because maybe this is a bit far away from competition law. So I asked my colleague from the employment law department, which is a bit closer to these principles, because at least 4 of them are employment law related. So have you heard about the United Nations Global Compact? And she basically had the same reaction, like, United Nations what? So I'm afraid maybe the relevance is not as high. I have a theory why that might be, and that is that this Global Compact is basically a non-binding call to action for everyone who wants to engage in that, and unless you have reason to, or maybe you just want to, I don't know what the equivalent of greenwashing for the rule of law is, but you know, you can imagine a term, then maybe you subscribe to that. From a practical view, I would say one issue, for example, addressed by the Global Compact, corruption. Well, if you have a client and they have a problem with corruption because they somehow made a few bad choices and then suddenly things spiral out of control, let me just say, well, your first thought isn't what are the United Nations going to say about that. But having said that, does that mean that human rights and the public interest, I would say at large, the issues that are also addressed by the Global Compact, that this is of no relevance for a business lawyer? No, that would be wrong. Of course, these things are relevant, because at the end of the day, you have to advise your client on how to behave, at least if your client asks you. And even though my responsibility as an attorney is not towards, say, like the global human rights community, my responsibility is towards my client, but I'm also supposed to give good legal advice. And I firmly believe that there's good legal advice and bad legal advice, and I'm pretty sure that if I have a legal problem that has either human rights implications or broader public interest implications, and I start interpreting the law, which usually has some rather terms that need interpretation, and I interpret the law in a way ignoring both the human rights and public interest aspects, well, maybe I'm going to say what the client would like to hear, but then I'm not saying what the client should hear. And I think when it was asked before, what can we do as lawyers to promote the rule of law? I think one thing we all can do, regardless of what we do, we can behave with professionalism and integrity in our day-to-day job. And I think if we do that, then we are already a big step forward in leading towards a just world, at least assuming, which I think in Europe is largely the case, that the laws that we are applying are indeed fair and intended to bring us to a better world. So we will not be the person with a wrinkle in the eye and look for the loophole, but give our clients the truth, and that is what we believe the law really is. If the client asks, what could the law be? Maybe, if you bind it a bit, okay, then maybe we will say that as well, but at least the client will know, okay, now you're going a bit into the territory of wishful thinking, and we should make that clear to our clients. Stepping one further step back, because when I was asked to speak on the panel on the rule of law and business, my immediate reaction was, yes, this is extremely important. I think for us as lawyers, we are also entrepreneurs in a way, evidently, because without the rule of law, we would basically be out of job. I guess then people would take their money to lobbyists and not to lawyers to get some services. But it is also incredibly important for society as a whole and for business as such. Because what is the rule of law, to me at least in essence, is it's about constraining power to keep our societies free and fair and prosperous. And in today's day and time, when we have global companies that are more powerful than many nation states, then I think it is clear that also business power needs to be constrained. And that's in particular also what competition law does. We're doing a lot of work on abuse of dominance, and the abuse of dominance is really about market power when you have companies that are so strong that they are actually a risk to a free and fair and prosperous society if they could behave unchecked. Having said that, I think the rule of law for businesses themselves, it has three important aspects. The first is compliance. If you're a business, at least my clients, our clients, they in general, they want to be compliant with the law. They want to be on the good side of the law, but in order to be on the good side of the law, you have what we already heard before, you need predictability. And you don't have that if you don't have the rule of law. So if you're a business, you want to make business decisions about how to behave in the market, you are really happy if someone can tell you what is legal and what is not. The second thing, protection against others. Let's say if maybe an authority runs a bit roughshod over you, then you're quite happy that you have right to a fair trial, hopefully an independent judiciary, etc., etc. And last but not least, and I think that's also very important, the rule of law also provides opportunities to businesses. It was mentioned pro bono work, and we did that also recently with a, let's say, semi-pro bono work, where we helped our client, basically a startup with 2 employees, to get access to essential data from a global company, 300,000 employees. And we achieved that for a client. Why? Because we were in front of a court. And in front of the cartel court, it doesn't matter whether you're big or small. What's important is whether your arguments are strong or not. And that has something to do with the rule of law, and thereby we can contribute as lawyers by doing our job well to a society that is freer, fairer, and more prosperous than it would be without. Thank you very much.
Thank you very much, Moritz. I believe that honesty is always a good virtue, so thank you for that view. Next, I would like to welcome Wojciech Vyarovsky, the European Data Protection Supervisor and a professor in the Department of Legal Informatics at the University of Kedamsk.
Thank you very much. And to this presentation, I will add that I was the Vice President for Academic Activities and Secretary General of ELSA Poland, 92 to 95, and the Director for Computerized Information. It was called at this time Computerized Information. Now it would be IT. In the ELSA International 95-97, and I was also the head of the ELSA Lawyer Society, which was the previous association of the ELSA alumni in 2001 when we had the 20th anniversary here in Vienna. And also the main organizer was actually, from the seniors' point of view, Johanna Kaupinen, who is here as the main player as well. So, well, Moritz actually led me to start the presentation a little bit different than I planned initially. And talking about this knowledge about the problem existing or the possible solutions proposed in the business, I would compare 4 sets of norms that we are meeting in our life. The ethical norms, the values, the law, and the rules. And I'm sure there is nobody in the room who knows what is the Madrid Accountability Declaration about the privacy. That's something about the ethics. I don't think there are too many people here who knows who is OECD guidelines on data protection. I think there might be some people among you who know what are the values that are kept in your countries because you know your constitution, and in some of the constitutions you may find something about privacy and data protection. Some of you who know international law a little bit better may probably hear about the laws like Convention 108 of the Council of Europe about the protection of the personal data. But I'm sure that everybody knows what is the General Data Protection Regulation, and that's the last part, the rules, the binding rules which are existing. Everything which I'll say in a while about the problem of compliance and what does compliance mean, and why it is not only compliance with the rules, are not going against the first statement that strong law is a good way of saying what are the rules and what the rule of law may mean. But at the same time, we have to ask ourselves, is the rule of law really a state environment that we live? No, it is not. The rule of law is not a state. The rule of law is an action. and it exists only when you are active. When you act, it will never exist without our activity. And achieving the compliance is just one of the activities that may lead to that. Because remember, our vision, ELSA vision, is a just world, not legal world. Just world, not Europe, not European Union, not Council of Europe. The world, just world where there is a respect for the human dignity. That's the most important, human dignity. And cultural diversity. Yes, there is cultural diversity. This is not European Law Student Association. That's European Law Student Association. So we are gathering law students that are geographically from Europe, knowing the differences that exist between our countries, but knowing also that the roots are actually the same. Compliant with law. Is it the rule of law? Where the Radbruch formula teaches us that something which is a law does not need to be really the object of the rule of law. Because there are laws which are not in compliance with the rule of law. So the rule of law does not mean to be up to the testing environment or to make the checklist that you go through and you know that you are compliant, so it means that you are going according to the law. This is not what we should teach the students as well. Many of us said that there is more education which is necessary. I agree with it. But I have to also say, also as a regulator, as the person who should enforce the law, that when a lawyer does not know what to say, he says, oh, we need more education. Or then he says, oh, that's an ethical issue. Yeah? So these are often the answers from those who don't know how to make the rule of law out of the law that we have at the moment, and out of our values that we have. The rule of law is not the requirement to them. That's requirement to us. And I have to say it also as a person coming from Poland, who used to be the leader of the democratization in this continent, who was admired for the changes that were done after 1989. And even when I was first applying for the job of the European Data Protection Supervisor, I met the people who said, oh, we like to work with Poles because you understand what is the rule of law. It seems not to be the true in 2021. Unfortunately, there is a very short path from being the leader to being an outsider. And if we don't act, we will go this way. The mere fact that something is compliant does not mean it's moral, does not mean it's legal. And at the same time, looking from the business perspective, we can say that we want to have the work operating the best, earning the money, creating the business opportunities. And we understand that there are some limitations that are set in the law. So everything which is over this limitation is something that we can do. Is it really true? Does it mean that everything which is feasible, technically feasible, is morally expected? But at the same time, does it mean that we want our law to be something which is setting in stones the things and not allowing us to innovate? These are the things that we have to bear in mind. And if somebody says that in my sector, this is not the problem of the human rights, because we don't have the problems of the child slavery, for example, in my sector, because I'm dealing with the media and with TV and with the new means of communication, then my question is, have you ever thought about the talent shows? Have you ever thought about the voice kits and the things like that? What does it mean earning money out of the job of the child? Okay, everybody say, there is a consent. The parents decided, and the parents consented in the name of the child. I was asked, or rather my daughter was asked 3 weeks ago by one of the big players in the IT business if she feels herself rather Polish or rather Belgian. Why? Because if she feels herself rather Polish, the age of consent, according to the Polish law, for having the account in this service without the parental control is 16 years old, 16 years old. And if you are Belgian, it's only 13. You can imagine that my daughter chose to be rather Belgian than Polish in order to go out of the supervision from the supervisory father. No, I'm joking, but it shows that the pure compliance with the letter of law does not answer the questions, neither about my daughter nor about her possibility to decide about herself. She is able to do it, but this is not coming from the letter of law. And then let me say a few words about the expectations towards business and the expectations that business have towards us. Mr. Krakow said that the rule of law requires the choices that may actually stop our competitive advantages, because we are not that advantageous as the other players on the market. Yes, it may happen. But on the other hand, one of the things which business can do in cooperation, international cooperations, with the countries, with the states where there is a problem with the rule of law, is to try to sell the idea that if you work with us, if you make the business with us, that means that it's fair and it's according to the rule of law. Because if you work with us, it means there is no bribery, there is no corruption. Then there is a requirement and expectations towards the Chamber of Commerce to pass these rules, that you will be first punished in our country for what you did in another country where there is no respect to the rule of law and bribing the people there. That's one of the ways to distribute the knowledge among the people working in business, not necessarily with the punishments that are done by the state, but probably also by the commerce players. And I'm not talking about child slavery at this moment. I'm talking about, for example, the double-use IT systems and IT software. The software that is created in our countries, in our country, that we think that our country is working according to the rule of law, but of course it can be used everywhere. And the cases of Hacking Team, the cases of Clearview, precisely show that the things which are created in order to surveil, in order to track the people, can be used as the technologies for the different purposes than those that were set here. And the question for us is, do we sell it abroad? Do we sell it to these countries? Do we sell it to the law enforcement authorities? Well, everybody can say, well, law enforcement authorities are the first ones who are expected to use the surveillance tools, if the surveillance tools exist. Yeah? But then they are used in Hong Kong. Then they are used in China the way that are at the moment. And I don't want to make it too long, because of course I can speak long about these requirements, but let me now say what are the requirements from business towards us, because I told you that these are not requirements to them who make bad things, but also to us. So me, as the representative of the administration, EU administration, I have to say that I also have a problem with it. How to use the rule of law rules in the compliance system that I'm dealing with. And just allow me to give the example. We have the financial intelligence units all over Europe, and all over the world. They are exchanging information between each other. And I think all of you who are here in the house, here in the room, are happy of that. Financial intelligence units from the states are exchanging information which are leading to the prosecution of crimes, financial crimes, in these countries. But what are the things that we took with it on board. First of all, we think that all this information are legally collected in the countries where they are coming from. So then you said that all the countries that are taking part in this FIU net exchange are the countries where the rule of law exists. And I'm not sure if this is really what was said. The information is exchanged via Europol. But there is nothing about it in the Europol regulation. Europol does not have the legal ground for being the hub for such an action. What should the data protection supervisor do who is supervising Europol? Of course, I should block it. I did it issuing the decision that they should either find the legal ground for that or they should move it to the other field, but Europol cannot do it. Yeah? Of course, moving it to the other corporation means that probably nobody will be supervising that. But going strictly according to the compliance, I'm expected, as the European Data Protection Supervisor, to say there is no legal ground for Europol to have the network like that. And if so, I have to add that all the states of the European Union are fully in favor of having this kind of cooperation, and they are working right now on the legal ground for that. So now tell me, what is my position as the supervisor? Should I block it because it doesn't have the legal ground now? Or should I wait until it will have the legal ground because the countries will create it? That's the questions. These are the questions that we have to answer ourselves and that you have to answer in your work, seeing what is the compliance, what is the rule of law, what are the values in between them. And now, if you ever thought that your education in the university should prepare you to pass the practical exams, you're wrong. Your education in the university should prepare you to answer in 30 years the question which does not exist when you are in the university. I had no course of European law in my university because I was graduated from the university 9 years before we joined the European Union. I had no data protection course in my university because the first data protection law has been passed in the European Union the year I was graduated, and in my country of origin 3 years after that. The university had no way to prepare me for the role of I play in the society than to teach what does it mean, the rule of law. Thank you very much.
Thank you, Wojciech, very much for this insight. I believe we are running out of time and are already a bit over, so we only have time for a couple of quick questions. Is there anybody here in the room who has a question on this? Yes, we have a question there.
I have to comment. I really believe that what we've been saying for us lawyers, when we say rule of law, we understand a lot of implications. The man in the street does not. A distinction has got to be made between rule of law and rule of justice. And this is a huge problem. There are a lot of unjust laws that are implemented. And then what's a judge to say? Well, I'm sorry, this is what the law says. It should be easy for a judge to say, this is what the law says, but it causes an injustice, therefore, I should interpret to get a just result. My question is there a realistic chance of changing the culture to go beyond rule of law to rule of justice? Thank you.
Are you pointing your question to someone specific? Yes.
Wojciech.
There's a question there, I guess. Should you collect the questions?
I would actually also like to comment.
Brief.
Okay, that will be really brief. I'm not a judge. I has never been taught to be a judge, mainly because when I finished my law studies, I decided that I'm not ready to give the judgments that would be about justice. That was the first reason for that, so that's why I didn't become the judge. I don't know if it's possible, Robert. I'm sorry to say that. But as Minister of Justice said, there are the problems with the position of the judges, with the attacks on the judges, but also with the profession of the judges as well. So these are all the things that have to be solved, and this is once again not a state, that's an action.
I would actually also like to comment on that. Yeah, Mark, I'm not actually sure that this is even something we would want to have. What you say, because I think you replace the rule of law by the rule of justice, but the difference between rule and justice is law and justice. Law is something objective. Justice is something subjective. And basically then, I mean, we have laws that are decided upon in a certain procedure by Parliament, and what your approach would basically lead to judges rewriting the law at will, and that's not what the separation of powers is about, and also not what the rule of law is about.
Thank you for that. One very quick last question. Yeah.
So, Michael Abiodun Ulatoken from the Bingham Centre for the Rule of Law, and my question is, now I'm on, excellent. Yeah, so my question is around, we've just heard, I think, a really important contribution from someone who's in a position to advise about how little credence and how little relevance some of the work going on in international organisations to try to bind business to act in a slightly fairer way has been. What if there was some kind of enhanced duty, probably building on the UN guiding principles on business and human rights, that said there was a duty to prevent, rather than what I see as a very watered down version that can't really bind anybody at present, where they essentially have a due diligence obligation that can be quite easily discharged by saying, well, we looked down our supply chain and these are the things we found. So a duty to prevent, should we have something binding that goes further than current instruments in order to actually make sure that businesses are held to account in a realistic way?
When the answer from my sector of law, when the General Data Protection Regulation was under preparation, there was a big call from the business, please do not over-regulate. We know our business much better than you, and we know our business models much better than you, so we know how to apply the values and the principles that you will set. That's what the GDPR is all about. Now, when it's under enforcement, we hear the big voice from the business. Where are the checklists? Where are the instructions and interpretations from you? And we say, there will be no checklists. There will be no templates. You know your business better. You should be accountable. The accountability means that you know how to present. That's once again the role of the Chambers of Commerce, to help to create the ways to present the business models that probably I have no clue about, because I know nothing about the thermonuclear power stations. But they have to be compliant as well.
Thank you very much. I believe we have to finish now, but luckily we have the whole weekend ahead to discuss this further. So thank you very much to the panel and to the audience.
I thought everyone could hear me anyway. Just to say that the refreshments are after the next session, and that there's been a change to the programme, that we've combined the breakout sessions because we lost two of our speakers. One is Bojan Fras, who's not been able to join us for family reasons, and he sends his apologies to everyone and his best wishes to his friends in the audience. So the next session is going to discuss trade and globalisation and the rule of law, and then there will be refreshments after that. But if you need a 5-minute break, I think perhaps we'll take a comfort break, as they say in the UK. We'll start in 5 minutes' time.